So why don't we, why don't we go ahead and get started? So I'm Scott Hemphill. I'm on the law school faculty here. Pleasure to welcome you to our final panel of the day. For those of you who've been with us all day, we've heard a lot today. We've been drinking from a fire hose about mergers, exclusionary conduct, the consumer welfare standard, concerns about aggregation of political power, among lots of other topics. Our modest job here is to try to tie together some of what we've heard across the previous 5 sessions and think a little bit about, the famous old question, what is to be done? Are existing enforcement institutions up to the task? Do we need to change the law, either antitrust law as it currently stands in the United States or as we currently think it stands in the United States, or other regulatory modalities that might be brought to bear? An analogy that's sometimes offered here is telecommunications regulation. Now, as some folks in the audience know, a lot of proposals have been mooted in various areas of this debate on mergers to increase the burden on defendants or simply ban some mergers by certain kinds of firms, or as to monopolization to lower the threshold market share for a finding of monopoly power, or perhaps to expand liability on refusals to deal, a topic about which we heard a lot in the previous panel. Or as a regulatory matter to impose interoperability type standards or line of business restrictions. Now, happily, we have here an all-star panel to help us think through these issues. I'm going to introduce each of them briefly in alphabetical order. Diana Moss is an economist and president of the American Antitrust Institute, an independent organization that, as folks in this audience well know, promotes competition through research, education, and advocacy. She recently testified in the Senate about a very relevant topic here, competition in digital platforms, particularly the acquisition of nascent competitors by leading platforms, and on another recent occasion about the consumer welfare standard and antitrust. Thomas Philippon is the Max L. Heine, want to get that right, Heine Professor of Finance at the Stern School of Business here at NYU. He was named one of the top 25 economists under 45 by the IMF, and won a prize for Best European Economist under 40. He's the author of a new book, The Great Reversal: How America Gave Up on Free Markets, which has received strong reviews in the FT, Wall Street Journal, and New York Times, among others. Joe Stiglitz is a university professor at Columbia University, co-president of the Initiative for Policy Dialogue at Columbia, and chief economist of the Roosevelt Institute. In 2001, he was awarded the Nobel Prize in Economics for his analyses of markets with asymmetric information. Former chair of the Council of Economic Advisors and former chief economist of the World Bank. His most recent book is People, Power, and Profits: Progressive Capitalism for an Age of Discontent. I think that's the most recent book. There may be one even sooner than that, more recent than that, but that's the most recent one that I know about. There's a lot of books. Corinne Wong-Ervin is the director of antitrust policy and litigation at Qualcomm, which we've heard some about earlier today. She's a senior expert and researcher at China's University of International Business and Economics and an academic advisor at China's University of Political Law and Science. She formerly served as director of the Global Antitrust Institute at George Mason University School of Law and in senior roles at the Federal Trade Commission. Finally, Luigi Zingales is the Robert C. McCormick Distinguished Service Professor of Entrepreneurship and Finance at the University of Chicago's Booth School of Business. He's also co-director of the Stigler Center there, whose Committee on Digital Platforms recently released a much-discussed report about some of the topic for today's panel, what ought to be done to increase competition in these markets. Like Thomas, a winner of the Best Economist Prize, and his books include A Capitalism for the People, Recapturing the Lost Genius of American Prosperity. So first, please join me in welcoming our panelists. All right, I'm going to sit down because my work is basically done at this point. So what we're going to do is I'm going to pose a series of questions. We've got a couple of topics we'd like to cover. One of our panelists is going to kind of lead the way in responding, and then we'll have a kind of back and forth as other panelists chime in. So our first topic picks up where I think at least one of the panels left off, which is mergers, bread and butter, antitrust topic, staple of antitrust enforcement. Now, we've heard a lot about this topic, and in particular, some of this discussions raise the question of whether merger control needs to be adjusted to handle a platform's acquisition of nascent competitors. Sometimes we say potential competitors, but I think nascent competitors is the way to think about this. Facebook, Instagram is the one that's always first on our lips, though we could think of others that maybe fit this pattern. Debbie earlier, poured some cold water on these cases. I think Tim offered some responses. So Diana, let me start with you on this. What's your take? Is this a real problem? If so, do we have the right tools? Do we need adjustments like the flip of burden, or perhaps some special, more aggressive set of rules for platforms?
Thank you, Scott, and thanks for having me here today. It's an honor and a pleasure to be here, and a little daunting to be on an all-economist panel. It doesn't happen very often, but it's always an education. So what I'd like to do is take you through just a brief tour of the 4 areas of mergers that we see happening in the economy today, and I think that the antitrust agencies struggle with. And that's 4, not 3, and you'll see what they all are. So horizontal mergers. I think it's safe to say that the area of horizontal merger control is very troubled. Horizontal mergers are contributing and have contributed over a long period of time of under-enforcement to growing market concentration, even in antitrust markets. So you may say, well, all those studies from the CEA and elsewhere are all about aggregate market concentration. Well, very easy to cite to economic literature and systematic or systemic changes in markets, antitrust markets, as a result of successive mergers in key sectors. Most recently, of course, we had the DOJ approve the Sprint T-Mobile merger, a big 4-to-3 merger in wireless communications. 43 mergers, if you look at John Quokka's work at Northeastern University, 43 mergers are very tightly correlated with adverse post-merger effects in terms of higher prices, lower quality, and the like. Yet they continue. We saw the DOJ take a big remedy in Sprint T-Mobile, which is largely a conduct remedy to magically produce a rival in Dish Network to replace the competition lost by the merger. All right, that's horizontal mergers. Vertical mergers. I think the takeaway in the vertical space is what I call the verticalization of key sectors. So food and agriculture, healthcare, also telecommunications, where we see massive vertical integrations creating 2, 3, and 4 level systems. So take Bayer Monsanto or Dow DuPont. Those are now 4-level systems where we have innovation in traits, we have seeds, crop seeds, GMO seeds, we have agrochemicals, and now they are adding digital farming assets to their portfolios. So these are 4-level systems, and we see them proliferating everywhere. Not only does that raise barriers to entry for entrants that are competing, say, at a single level, innovating in traits or innovating in a healthcare market, for example, but it shifts the competition paradigm away from competing at individual levels in markets to competing between these behemoth vertically integrated platforms. So in ag biotech now we see 3, we've gone from 6 to 3 in a matter of only a few years. So we have 3 big ag biotechs. They're all vertically integrated across all the 4 areas I just mentioned. And so really the only effective competition will come from competition between those large platforms. So we ask ourselves, is there enough competition between platforms to generate benefits for consumers? And I think the answer to that is no. And I think antitrust enforcement has lost track of the transformational changes in these key sectors through vertical mergers. All right, potential competition. What we see in potential competition is really a lot of chaos. We're having trouble distinguishing nascent competition from a potential entrant to a small existing entrant. Somebody needs to sort that terminology out. But the bottom line is, we see a tremendous amount of activity that flies under the radar screen in potential competition, where we are seeing firms acquire small competitors on the edge of the market or who are in the market but are threats. Very little enforcement on that front. And then finally, there's a new class, relatively new class of mergers called concentric or co-generic mergers, where we're talking about sort of the ecosystem concept, where the digital platforms, for example, have a stronghold in a certain market like search or social media, but they are picking up assets to add and build out the ecosystem. Those markets aren't necessarily adjacent to one another in a horizontal or a vertical context, but nonetheless add to the ecosystem, which is generally fueled by the use of consumer data to create connectivity and value through the ecosystem. Those types of mergers, as far as antitrust goes, have flown completely under the radar screen. So 4 areas of merger control. What do we do about it? Well, obviously some tweaks are needed, and we'll get into those as we go through the panel today, but certainly involves lowering evidentiary burdens for plaintiffs, government or private, shifting burdens to defendants to show that their mergers are pro-competitive, having some sort of coherent policy around remedies, meaning the best remedy in some cases is for the government to block a merger, not to let it through with an ineffective remedy.
Great. Luigi, let me bring you in here. What do you think?
So I think that in the space, especially of digital platforms, some of the obvious conclusions that we know from Economics 101 don't seem to apply or don't necessarily apply. So the idea, for example, that an acquisition that by an incumbent of a new entrant at a high multiple will lead to more entry and more innovation is something that we give for standard in neoclassical analysis. However, in a recent paper with Raghurajan, we show that once you introduce two elements, switching cost and network externalities, this might not be true. Why? Because if I am a customer of an incumbent platform, and a new one comes around with some attractive features, I might be not tempted to explore the new one if I know that eventually it's going to be bought and incorporated into an incumbent. So if I know for sure that the incumbent is going to incorporate all the best new features by buying them out and making it easier for me to adopt, I'm not willing to pay the switching cost. And if I'm not willing to pay the switching cost, the new entrant will not have enough eyeballs to be valued in the market. And so will not be paid very much, or if anticipates this, will not even enter to begin with. So by making it easier for the incumbent to incorporate everything, we are making it more difficult for new innovation to come along. Now, does this mean we should prohibit all new acquisition? Of course not. But I think, first of all, it's something we want to think very seriously. And second, we want to think maybe about the possibility of changing the burden of proof in situation of mergers when digital platforms are involved, especially in light of the fact that these are markets that tend to tip in one direction very easily. And so if we allow an acquisition at the right time, it becomes irreversible. So I think that if today we try to go back and undo the Instagram, Facebook acquisition, I'm not so sure that we have the same benefits that we would have had we stopped it at the time. And why? Because as Tim was describing earlier at lunch, there was a moment in which actually Facebook was vulnerable, so there was a possibility of competition. Now Facebook is very entrenched, so once you sort of are trying to undo it, I don't think it's going to be very effective. So I think in these particular cases, given the enormous amount of power in many dimensions, and later in the conversation I'm going to talk about the political dimension, which is very dear to me, but given all these elements, including the political dimension of platforms, I think that having a system that gives them the advantage of litigating to death and basically make sure that nothing gets done is excessive, and we should actually shift the burden of the proof.
So Corinne, let me turn to you. You know, putting on your lawyer hat, it's your comparative advantage of the rest of us on or the rest of them on the panel, and thinking about practicalities and legal structures here, what's the case for or against, a different rule for nascent competitors? Should we be, or tech platforms, more generally, should we be altering our rules to take into account some of these specific economic factors that have been identified?
Sure. So thank you to Eleanor and the other NYU professors for inviting me. It's a privilege to be here. So, I'm aware of my likely audience, and I'm going to try to ask questions, right, so that we have a discussion. And I'm going to try. I do have some views. On nascent acquisitions, I'm going to talk mostly about some of the proposed legislation we've seen from Senator Klobuchar and others to either ban certain acquisitions or create presumptions of illegality based on market share. And so I have, 4 main points. The first is that I think we need more evidence, right? That without substantial evidence, we really risk harming consumer welfare and innovation, including deterring startup activity. So why don't we wait for the results of the FTC's new 6B study, right? They just launched this big study. Why don't we wait to have some evidence so we can base our policy and laws on evidence? Some things that I would like to know, for example, are, startups may engage in strategic behavior to make themselves look like viable competitors so that they're more attractive acquisition targets. But when you actually examine the incentives and abilities, it may be that they don't have any concrete plans to actually enter independently. So we need to know this. We need to study this strategic behavior to the extent it's happening. The other thing is that I think we need substantial evidence, and we can't just assume that firms would have been successful but for a merger, right? Acquiring firms do provide substantial resources, know-how, synergies that can really make these companies a success. The second thing is that I think the existing studies that we have and that the ones we generally rely upon are drug studies. And I don't think that they are generalizable to digital markets, right? As we all know, in drug markets, they're highly regulated, they're standardized, they're well documented, you have set milestones, and you don't have any of that generally for digital markets. The other thing is that in drugs, it's usually pretty straightforward how to identify substitutes based on functionality. Whereas we don't have that in digital markets because the products are generally highly differentiated. Third, let's say we did have a systematic so-called killer acquisition problem, then doesn't that also necessarily mean that we believe that we have routine entry and thus monopoly power may not be as durable as we think and might be subject to disruption? And fourth, no, I guess not. No, one person says no. The other thing is that, to me, it seems not quite right to base success and exponential output growth to make that the basis of, to make that evidence of anti-competitive effects, right? When we're talking about antitrust, we're talking about reductions in quantity and quality and innovation and transfers away from consumers to producers. And so my last point, relatedly, is, what are we looking for? It's just not clear to me. Former longtime economist at the FTC and now Professor John Yoon, posed the question, let's say that we take Facebook and Instagram, and we say that the post-merger conduct is evidence of an anti-competitive outcome. Well, what would a pro-competitive outcome look like, right? So let's suppose that Facebook had discontinued Instagram a year or so after acquiring it. Would we then say, Instagram must have been a poor quality product and thus the merger was benign? Or would we say, Facebook was successful, it killed a potential competitor? Or let's say that Instagram did grow, but it fell below the projected prior projections. Again, would we say that Instagram was an average product and the merger was benign? Or would we say, well, Facebook didn't invest enough? So my question is, what are we expecting to find in order to determine whether a deal is anti or pro-competitive? I think if we cannot answer that question, if we don't know what we're expecting to find, then we can't say that the agencies are making systematic errors.
Can I just one point?
Briefly,
I think
yeah.
it's very easy. You want to see improved quality on Facebook, and quality is measured in protection of investors' data. We see a clear deterioration after the mergers with Instagram of the protection of investors' data, and that's a sign that is anti-competitive.
So Luigi, if that's right, what do you do, and I'm interested in bringing Joe and Tamai in on this too. What do we do with what I took to be one of your comments, which is, yeah, but now it's happened and, we didn't do it beforehand. I mean, I took you to express some skepticism, maybe undue skepticism from my own standpoint as an immoderate moderator on this particular topic. Skepticism about whether ex post enforcement is worthwhile because you can't, it's too late, right? You can't fully restore the competition before.
I think the breakup now might be too late. What I would like to have, and we discuss later, is interoperability that creates more competition. I think that's a better way to handle. However, she cannot say that we don't have a way to look at the anti-competitive behavior. There is a clear way, either price or quality. And quality is deteriorated massively in Facebook. Facebook started, when it was competing with MySpace, started as the better privacy system vis-a-vis MySpace. And once it became a monopolist, now is so intrusive in our life that we cannot even imagine. I don't know why this is not a sufficient metric.
Let me,
Can I just say one other aspect of that particular one? If you asked what was the price they were paying for, it was clear that it was, the only justification of the price was an anti-competitive action, that they could have developed their own platform.
you're suggesting looking to the premium as a way of
As
identifying.
at least an indicator, and you think about how is that sector going to evolve, and what are the potential kind of effects of the kind that Luigi talked about. I haven't found a persuasive reason why at this juncture you can't break them up. You can't undo all the harm, but it's not like you can't separate out. They have separate platforms, and so you could separate them out.
And are you leaning also partly on, look, there's doing good in a particular transaction, but there's also, the deterrent effect of, look, even if you can't fully restore the competition, and even if it wreaks some harm on a target to undo a previous transaction, it's
Exactly.
still, to have it focus everybody else's mind is.
I think you need some ex post enforcement. Maybe other people have views, but I think you need ex post, you might call ex post enforcement. If they say, for instance, that this merger is going to lower the price, and then it raises the price, I think you should consider breaking them up, or at least imposing other remedies like taxes or regulations to say, if you do that, you'll be subject to some kinds of ex post control.
Tamai, do you want to respond briefly on
Can I
this?
just ask a question?
Yeah,
So,
sure.
I'm interested in what the evidence is that Facebook, it's the privacy is the quality has gone down, and also how you're sort of, defining, what privacy we want. To me, I feel like there's, dangers in relying on stated preferences or survey data, and that when you look at what consumers actually do in the marketplace or their revealed preferences, that it's very different. So-
Revealed by their multiple choices they face?
Yes, if you want to know when your kids have a gathering in school, you have to go through Facebook. So you have no choice. If you have a monopolist, you have no choice. So I think that the revealed preference, the choice is, I don't know if my kids come home today or not because the school communicate everything through Facebook. Of course I have to use Facebook, even if I don't want to.
Tamai, do you want to come in on this since you haven't said anything about this topic yet?
Well,
You're lead on the next topic, so,
Well, that's just specifically on the issue of data privacy. The other thing that we have done a lot of research over the past 5 years on this specific question. And then all the research, both theoretical and empirical, points towards the fact that there are data sharing externality. Or in other words, the revealed preferences you're going to get from one individual online is not going to be the one that they would choose if they could all choose together. So once I share my data, then I'm going to influence everybody else's choice. And the biases, both in theory and empirically, are towards too much sharing. because there is a negative data sharing externality. So you couldn't use just individual choices to motivate that, just on a specific point.
So I'm going to give Diana a brief comment, and then I'm going to move on to the next.
Can I ask? Oh, I'm sorry.
Okay, so I'm happy to stay on mergers. This is really just for my panel. We have a collective action problem because we're not going to get to the later topics if we spend all of our time on mergers. I'm happy to, but
I'll be fast on my comment. So I just want to sort of tee up this dichotomy that we have in antitrust right now, where we're in sort of the infrastructure industries and telecom, healthcare, you name it. We have a growing body of evidence, right? We're all looking for evidence of harm and adverse effects, but that body of evidence is growing. It's growing through merger retrospectives. It's growing through the fact that antitrust remedies are failing. We now have this growing list of failed remedies. That's a failed merger. We see that mergers themselves are failing to actually to produce value even for their shareholders. So we have a growing body of evidence outside of the digital tech sector. It is really hard to ignore that growing body of evidence and the principles upon which it is built, and then say, oh, well, we don't have any evidence in the tech sector that these mergers are harmful to competition and consumers. So somehow these two bodies of thought and evidence need to be linked together, and enforcers need to learn and sort of cross-fertilize over to the digital tech sector, loss of choice, loss of privacy, or loss of quality, the whole list of ills, and we're not seeing that. And that needs to be leveraged into enforcement on that side.
And can I just add one thing, which both Thomas's book and my book emphasize, is the growing market concentration across the economy. So it's become a systemic problem now in our economy. It's not only that it shows up at the individual sector, it's sector after sector that our economy is less competitive. And it's particularly true in the United States, is what Thomas argues, and I don't want to speak for you, but that will have long-run implications for the dynamic nature of our economy. And it shows up in many, many different ways, not only in markups, concentration, the entry of new firms, the fraction of firms in the economy that are young. All these are symptomatic of something not working very well.
Scott, just one last thing, very short on this topic. I don't think you should think that, so it's about making up. You say you make a mistake in the past, in that case, under enforcement of merger, and then the question is, what do you do going forward? Well, first, of course, you stop digging, so you change to make sure the merger become more difficult, or the burden of the proof changes going forward. But I don't think you should, this is not the only place in public policy where you have to make up for the past. I mean, I work a lot on monetary policy, for instance. We are always behind the curve in some extent. And then we have plenty of well-established framework to try to make it up. Like, if you didn't cut the rates quickly enough, or if somehow you fall behind on your target for inflation, that means for 5 years you will have lower interest rate than you would otherwise, and you make it up that way.
Yeah,
so somehow, why is it that in merger policy it's the only place where you can't have this, automatic feedback?
It strikes me, just picking up on that a little bit, that whatever you think the right aggressiveness is as to merger enforcement in big tech, the optimal mix of ex ante and ex post enforcement is unlikely to be 100% ex ante, right? And I think that's a commonplace, but I think we are somewhat, at least in the U.S., caught in the thrall of ex ante enforcement, at the expense of thinking about, going after things once we realize that they have anti-competitive effects. Let me turn now to, pick up another, thread from the discussion that we've been having so far today about exclusion. There's a lot of different ways of putting this. One way is maybe to think about concerns about potential conflicts of interest in the roles played by some of our leading platforms. Google Shopping came up as probably the case that's furthest along in the pipeline in some sense. Of course, Google Ad Tech, Amazon Marketplace. We have a few other examples where concerns have been raised. I think there's a concern among some that U.S. law might be, quite restrictive or too restrictive in this regard. Maybe as to the law in the books. We heard in the previous panel about deference to product design, Trinco's relatively narrow liability for refusal to deal. Susan, I think, aptly pointed out in the previous panel that the law is pretty restrictive in the U.S. So my question for this group is, All right, well, we're talking about legislative change in this panel. What, if anything, should be changed, either as to the substantive law, as in these examples, or the standard of proof needed to establish an anti-competitive effect? So, Tamara, I'm going to start with you. How well are things going in the U.S.? What, if anything, do you think we ought to be looking to change in this particular space?
So, we had a lot of discussion on specific cases and proposals also in earlier panels, but so I tend to view most of this question through the lens of ease of entry. I think the thing that's changed the most over the past 30 years is the fact that some markets have become just very hard to enter. And then if you think about then, the next question is, so sometimes it's because of regulations, and sometimes it's just because of access to critical inputs. And the critical inputs today are going to be data and key human capital. So once you think about that as the overarching framework, then just for example, the distinction between the harm that you would get from horizontal versus vertical mergers, they become much less different. You could very well imagine a vertical merger that gives you much more access to the critical inputs, therefore raises barriers to entry for everybody. If you think that the harm is from non-price harm from innovation, again, that's going to follow the same pattern. If you think that the key is access to data, and it's not data in general, like with access to whole data, that's not useful. What you need is access to specific data that allows you to know the intention of the customer. That's everything else doesn't matter. So it's the bottleneck where you can know the intentions. Same thing in that, if that's the key input and that's what drives barriers to entry, and therefore market power, that could be increased by just as much by vertical versus horizontal integration. So I think that's the key. And then if you look at the data, then on the other hand, to me, so one thing I show in the book, which I thought was interesting, was if you look at the history of entry across industries in the US, and you look at the past, so since 1970, then one fact that has changed a lot is the extent to which there is more entry in firms where profit margins or valuations are high. So, or in other words, when the Chicago School was making the argument that you don't need to worry about excessive monopoly power because it's transient, it was actually true in the data. So if you look at take data from 1975, rank all US industries by their profit margins or the excess valuation of the market relative to the book value, like Tobin's Q, all measures you can like, you're going to find a very tight correlation between entry rates, say between 1975 and 1980, and this excess valuation in 1975. Exactly as you would hope or predict in the competitive model, where today the problem is that correlation has become zero. So to me, that's the key issue, and that's the lens through which we should see many markets are just not contestable anymore.
So focusing, trying to keep us on the big tech frame a little bit, to the extent that
that holds in tech as well.
And I want to focus on that, to the extent that one or more platform markets, in your view, are not contestable. What's the answer here? Is it a digital regulator? Is it some kind of insistence on interoperability?
Or interoperability. So yeah. So in terms of the regulation, interoperability and portability of data, I think this should be like starting points. I don't know about the dedicated. I tend to view it as a European. It seems that in Europe we managed to do quite a bit in many of these markets. Not all, in fact. In the big tech is one where I don't think we are that successful actually, without changing so much the basic principles. We still have a consumer welfare standard. We have a regulator which looks like it hasn't changed that much, and I think you can still do a lot within that framework. So I don't have a strong view on whether we need a specific regulator for that.
Mm-hmm, mm-hmm. Other reactions on this, Luigi?
I am very big fan of data portability. In fact, of a common API for many digital platforms, because I think that Thomas is absolutely right that the existing data represent a huge comparative advantage. But from an economic point of view, we know that data have at least one characteristic of a common good, public good, that is non-rivalrous. So many people can use the same data. So the fact that you have a monopoly of data very often acquire as a result of transaction. The fact that I cannot transfer my data of my transactions as Citigroup to another potential lender, I think is really hurting competition in a major way. So the ability to transfer this as it is in the Open Banking Directive in Europe and in the UK is very important. But you can go even farther. In a sense, part of what makes it difficult to compete in social platforms is the fact that you don't have the portability of your social graph. And if you make it easier to have this portability, I think that competition might arise. So I think one of the reasons why we don't see it is because even if in principle this is sometimes open, Facebook can block it at any moment in time. So you will never start a business model where you're going to use effectively that open API, because the moment you become a threat, Facebook is going to close it. So you need to have a law that says you have to have not only an open API, ideally a common API. That is, by the way, what Amazon does inside Amazon. The reason why Amazon is so effective at starting and closing new business is because early in the 2000s, Jeff Bezos issued an edict and said every business should have a common API. And so they interact through this common way to get the data from that different part of the business. And if you want to divest or not divest the business, it's very easy because there are large pieces of Lego that are connected by this. And we don't see why we cannot do that more broadly.
I gotta say, when you started, maybe I misheard, one way of interpreting where you started was that, you know, my personal data is non-rivalrous. That makes me nervous, right? Because I imagine it being syndicated here and here. I mean, this, of course, was playing into a defendant argument in these cases that, you know, interoperability from a privacy standpoint might raise some concerns. I wanted to turn to Diana. I think she had some reactions here.
Yeah, I just want to add a couple of points of nuance to the discussion around data. So the digital platforms are fueled by data. These ecosystems of interconnected markets work because of data. It's leveraged from market to market to market. And the way it's leveraged and the way it holds the ecosystem together is through the data. But we're not just talking about data, raw data, and the collection of raw data and caches of data. We're also talking about data processing capabilities. So, you know, if you look at Google, for example, that's all machine learning. That's pumping data through the system, applying artificial intelligence. You know, the machine learns over and over in an iterative process. So process data, I think from an antitrust standpoint, a competition enforcement standpoint, presents potentially different issues than just data caches. For example, mergers involving combinations of big data sets or raw data may pose barriers to entry. Process data or data processing capability, I think, potentially poses different problems like leveraging and foreclosure across markets. So that's one thing. The other distinction that's really important to make in the digital platform space is we're dealing with two very different models. One is the B2B market, right? So these are businesses, for example, that go to Amazon or Microsoft or now Google, now that they've acquired Looker, and they want cloud computing services, right? That's a B2B transaction. Most of the media and the press attention and the concern is in the B2C markets, where consumers their data is being abused, they have no protections. That's a B2C problem. And I don't think we think enough about those distinctions and how competitive problems arise in both of those types of models, but they have very different implications for antitrust.
Let me get Joe Corinne in here.
Okay.
Yeah, Joe.
So first, I want to go back to, you might say, classical industries before AI. And a lot of the problems we're facing today were problems that were there, but AI and the characteristics of the new data, of the new sectors exacerbate them. So for instance, contestability theory never made much sense, and you can show markets are not contestable if there's even epsilon sunk cost. But of course, this is a sector where sunk costs are very large. So the presumption is that markets are not contestable. And so that whole theory needs to be, you know, totally put aside. Secondly, the welfare consequences of vertical mergers are adverse if there's imperfect competition horizontally. So a lot of the theory was developed of vertical mergers where there's a very strong competition. But when we have only 2 or 3 providers, and then you start having vertical mergers, we know even without going into the new sectors that has very adverse welfare consequences. So we should remember that the theory that a lot of people, the Chicago theory was all based on strong competition. That's just not true in any of the sectors that we're talking about. And so that should make us, at the beginning, very skeptical about these vertical mergers or about going into the conflicts of interest that the sectors become rife with. The point that Diana made, I think, is really important when it comes to the issues of interoperability. Some of the tech companies will say they're perfectly happy not storing any data, but they embed the data in their programs. And so they could actually destroy all the data but since their machine learning, the AI, has already incorporated that data, that gives them the competitive advantage that is the entry barrier for anybody else.
And that would undermine portability as a solution, presumably.
That undermines portability as a solution. What I'm saying is,
Right.
particularly to focus on what Thomas said, is a big issue is entry barriers. If you already incorporated that, and then you destroy it, the data, you said, I can't give it to you because I've already destroyed it. And it's embedded in my program, and I can't even tell you where it is. I don't even know where it is. That really gives you a competitive advantage and makes entry more difficult.
So let me try to pull us back in on the what is to be done, therefore, right? So let's grant for a minute, let's assume that it's the case that, the ongoing and massive investments in AI and machine learning techniques, right, are pro-efficiency, pro-innovation, are contributing to the position of a Google or a Facebook or an Amazon by dint of, right, magic language for some of them, sort of skill, foresight, and industry, right? And so we think there's no chance, let's imagine, of a straightforward Section 2 case with respect to this, right? Basic antitrust is essentially off the table, holding to one side the possibility that, notwithstanding Trinco, there's an essential facilities claim out there, right? But let's imagine that none of the other exceptions for legal geeks in the room apply within Trinco. There's not a change in course of dealing. There's not inconsistent treatment. It's just a really powerful position that was achieved, again, by dint of skill, foresight, and industry. And so then we're left thinking about no-fault monopoly. My colleague Eleanor Fox is in front of me, so I'm going to talk about no-fault monopoly. Is that something we should be thinking about? Does this start to look enough like, a natural monopoly that, we should start dusting off an old, telecom regulation playbook, think along those lines? I'm coming back to the digital regulator, in that respect. What do y'all make of this? What's to be done if that is sort of the state of play, which it sounds like from what some of y'all are saying that might be the case. I'll come back to Joe for just a minute on this.
Yeah, I agree that we are in a situation where you have to think of the regulating these as natural monopolies, thinking about these as natural monopolies, and what do you do with a natural monopoly? So I think the European standards of abuse of monopoly power ought to be incorporated into American law. So I'm not talking now about what the law is, but I'm talking about what I think the law should be. That, and again, there are parallels to what has happened in other sectors when somebody got a monopoly on drug prices, on a drug, whether it's legitimate or not, and raises that price 1,000% over marginal cost. That's an abuse of monopoly power. This sector has much more potential abuse for market power in a whole range of areas. Privacy, political manipulation, hate speech, of both what it does and what it doesn't do. And I'm going to say, at a more fundamental, as an economist, one of the more fundamental problems is it's engaged in price discrimination. And one of the things that we teach in our basic economics is that what makes for an efficient market is that everybody faces the same price, so the marginal benefit and the marginal cost for everybody's the same. And they've destroyed that by the ability to target pricing and target other things. So the potential harm, and I haven't listed all the potential harms. We talk about a market of ideas or a market of information. Markets are transparent. This is a very non-transparent market. And you don't know who is being targeted with what information and with what effect.
You're not saying price discrimination is all bad.
I think the presumption should be that price discrimination is bad. And I think there are some cases, obviously if it's cost-justified price discrimination, and there are some cases where you can say it's related to some recovery of fixed cost. There may be, there's an argument there. But price discrimination of the kind that we're seeing I think should be presumptively bad. What we know is going on, one of the questions I've asked these guys is, we know that they engage in pricing, the effect of which has racial consequences. They say they can't even tell whether they're engaged in racial discrimination. And they say that they can't even provide the models with which we could ascertain whether they're engaged in racial discrimination. They're saying, these are just machine learning and they've come up with these results and, we have to live with the consequences. And I say, we don't have to live with the consequences. One of the things that other countries are thinking about doing is demanding, at the minimum, transparency. That you have to reveal at particular moments of time, enough code that we can test whether the effect of what you're doing is discriminatory.
But
Let me get Corinne and then turn to Thomas. So, Corinne, reflecting on what you've heard, across both thinking about exclusionary conduct, but also some of the, what are backing into proposals on no-fault monopoly, right, which sort of leads us toward ex-ante regulation as opposed to the usual ex-post mode of antitrust enforcement that I think is perhaps more familiar to a lot of the people in the room. What do you make of this? Is this a frolic and detour, or is it something that we should be, considering seriously?
So I have so much to say, but I will try to limit myself. I am concerned about ex-ante regulations because I think that they can be very rigid and lack the flexibility of our existing antitrust and consumer protection laws. Coming back to, I'm trying to think what to respond to. I'll just talk about a little bit of self-preferencing. I think, again, we need evidence. The question of harm with self-preferencing is an empirical question, right? So let's take Google, for example. You cannot say whether Google has a competitive advantage in terms of economies of scale and scope such that an equally efficient competitor cannot compete unless unless you know why Google is a success why Google has such good search results, right? Some people say, well, it's data. It's definitely data. Well, we do have evidence from Catherine Tucker and others that it's not volume that matters, right? That it's how you use that data, how effective you are. I think, another area of evidence is we need quantitative evidence on user switching behavior. Having some evidence about how consumers, how often they multi-home, even for some of their search results, could really help to answer the question of what degree of independence Google has. And coming back a little bit to, the other thing is that, I think that we're moving away from sort of focusing on things like coercion for tying and almost punishing like a behavioral nudging standard, right? So we're saying that, and that to me sort of essentially asks whether consumers are making the right choices, right? So unless you have evidence that informed consumer choice is just not possible, then intervening is really the government saying, you know, your choice is wrong and we're going to overrule your choice. And to me, that's not what competition about, right? Competition is about sort of championing consumers' preferences by forcing producers to honor consumer choices.
All right, I'm going to get Thomas, and then Luigi, and then Diana.
Yeah, I just want to go back to your initial question. Are we back to the natural monopoly? So I think, first of all, I don't think we should ask that question for the whole tech sector. I think it's very different for Google, Facebook, Amazon, and Apple. And the second point is, is it the case that, you know, the antitrust toolbox is not the right one going forward? We need more. I think there is no question in my mind that we're going to need some more regulations and different regulations, that you can't do everything via antitrust or merger control. I think that's very clear. But I'm not that pessimistic in the sense that it is just not true that the scale to be efficient at AI is such that there is room for only one firm. That's just factually not true, point number one. Point number two, in many of the, take Amazon. Amazon has two businesses, completely independent, AWS, retail. In retail, they are 3 epsilon away of Walmart, not 10 miles away. In terms of market value, you can see it. In terms of prices, in terms of efficiency, they're just a bit better, but it doesn't take that much for these guys to compete. So I think there the issue is not that big. The digital advertising market is different. And I think that one needs specific answers. But it's not like across the board.
So if you were figuring out which of these is the most worrying to you,
I'm
you'd
not
start
worried
with
about
ad tech.
Amazon, no.
Yeah.
No, because I think they have a monopoly power issue that is fixable because it's not core business. I think that in the retail part, there is really good retail competitors that are very close by. If you look at prices, they are very close. They haven't raised their prices. If you look at capital expenditure, they are in a competitive environment where they feel they need to keep investing like crazy just to stay ahead of the curve. I'm not worried about that part. The cloud, very different. So it's so nascent that I think it's very hard to judge as of now. I think digital advertising and keeping track of people across different platforms, it's a whole different world, a whole different set of issues.
Great. Luigi.
So there's one thing I agree with Karen, that we need more evidence. The problem is that in order to do this evidence well, you need access to the data that the digital platform have. And the digital platform use the data to give it to their friends that are going to find only certain results. And this is going to destroy all the evidence and also our academia. I give you a simple example with Uber. Okay, if you are pro-Uber, you get Uber data, and you're going to find results that are in favor of Uber. If you are trying to find something that is negative about Uber, for example, how many people they kill in accidents, you don't have access to Uber data, and every paper you write is rejected by people who are at Uber or associated with Uber because you don't have the best data, which are Uber data. And so basically, if you are in that space, either you are a friend of Uber or you don't get tenure because you're not going to publish any paper on that, okay? So this is the leverage of the power of data to capture academia in a most dramatic way. That's the reason why we need the digital authority that forces open access to the data to all academics in the same condition. Because otherwise, the big companies will decide who are going to be the next academics out there.
A lot of academics looking for data in the audience. I didn't expect that to be quite so big an applause line. Diana.
Sure. So can we just all admit, as a group, that this is not all an antitrust problem, right? This is what Professor Stiglitz has described very well a few moments ago is a public policy problem. So I think declining competition in general is a public policy problem, and it requires a public policy solution. I think the digital platforms in particular are a public policy problem. And part of the frustration in the antitrust community and this raging debate around us, which is a terrific debate, we're very in it, my organization, is that we're trying to task or load up antitrust with more than what it was intended to do, and more than what it can do by the design of the laws and the constraints that we face over the last 130 years. So I think the sooner we admit that these are public policy problems, we can then migrate to a frame of a public policy solution where we're looking at the antitrust laws and how they can be applied. But we're also looking at regulations potentially. Economic regulation, social regulation is probably the best candidate to deal with privacy issues. Antitrust isn't going to fix the privacy issues.
So let
platforms.
me pick up where Diana's left off. This is also picking up, I think, on one of the themes from the previous panel, which is, what are we supposed to be doing? What's antitrust about? What is it that it's maximizing? I'm going to start with Corinne on this. I mean, there was a lot of discussion at lunch about the consumer welfare standard. I think Tim said, look, we've unduly elevated it. We heard some pushback from different perspectives from both Tad and Steve, sort of bringing us back toward consumer welfare. So I guess just to open things up for Corinne, I mean, is consumer welfare really just about consumer prices and output? I mean, I think Tim conceded a sort of primary counterexample, which is Microsoft, which is not a price case, right? It's an innovation case. So at least we have one really large, important Section 2 case that was about the kinds of things we think effective antitrust enforcement ought to be about. And if we were going to change it, what would we change it to? So let me start with you.
Sure. I mean, just to quickly respond to the renewed concentration contention, problem that I've heard. So I think there's problems with the literature, but let's assume that we had a concentration or competition problem. That the aggregate statistics that folks are relying on is really tangential and perhaps even irrelevant to whether particular conduct results in anti-competitive harm. And that's what we're worried about here, right? Whether particular conduct is harming consumers in competition. So, to your question, I agree with the last panelist that consumer welfare standard is a broad standard. I think it really values what consumers are willing to pay for. Very importantly, it tethers antitrust to the methodological rigors of economics in terms of theories that can be tested and rejected. I'm very concerned with a lot of the proposed alternatives to the consumer welfare standard. I think that they're not administrable, but I also think that they would impose subjective notions of what a fair or normal competitive process might look like. When I was at the Federal Trade Commission, we would, travel the world, mostly in Asia, where they consider non-competition factors, and really talk about the dangers of trying to incorporate things like employment or inequality. The fact that it's difficult enough to weigh and balance anti and pro-competitive effects across a single market, but how do you weigh, anti-competitive and, competition and non-competition factors across all kinds of markets? And these public policy considerations may actually undermine consumer welfare. So, let's say you had a merger and you condition the approval on maintaining specific employment levels or local procurement. Yes, you might benefit workers or producers in the short run, but it might come at the cost of higher prices and a less efficient economy over the long run. So, we've really, for a long time, the U.S. government's been out there, DOJ, FTC, talking to foreign agencies about the dangers of really considering these non-competition factors. And I know people are, the enforcers I've talked to are very confused. Why has the U.S. been teaching this to them for decades, and then now, it seems like so many people are upset with the consumer welfare standard.
Luigi, you got a reaction on this?
Yes, I think that, again, I agree with one principle of Karen, which is the one that say that the antitrust should be administrable. And I think that I see the biggest contribution of the so-called Chicago School is that they try to force the discipline of having some rigor, some logic, and economics is very good because it tends to force logic. And I think is the great thing about the consumer welfare. Now, nothing prevents to have some other objectives with the same level of rigor and systematicity. So I give you an example. I've been to Chile recently. Chile is always sort of shown as the greatest example of application of Chicago economics to reality. And they've done a lot of things right. I'm not complaining. However, it's funny because in every industry, there are 2 or 3 producers, they're linked by blood or marriage, and they all collude. And it says, when I went there, I read verbatim Adam Smith, because Adam Smith has a passage that say, rarely men of the same trade, at the time were only men, meet even for enjoyment, that they don't conspire and collude, okay? And in Chile, this is like so obvious. For example, I'll give you an example. In the market for electricity, I spoke with one of these oligarchs, and he said, oh, there is perfect competition. Every time we have an auction, and everybody from outside of Chile participate, and surprise, surprise, we win, we have the lowest price. And then I spoke with somebody else and said, yeah, you know how the auction is designed? That the contract is, I'm exaggerating a bit, starts tomorrow. And you have to offer the contract from tomorrow for 5 years. Now, nobody else has the capacity to offer the contract tomorrow, so surprise, surprise, the incumbents win. So the part that the traditional Chicago antitrust misses is the power, actually, ironically, because at the same time Stigler was there and was saying the capture, is the capture that comes from being highly concentrated, okay? And Chile is the living example of how concentration leads to capture, leads to profits, and leads to a self-perpetuating circle. So I think that we need to introduce this aspect into an antitrust, and I don't want to touch the consumer welfare standard because it's love here. I want to add another thing that I call citizen standard that I am concerned about, for example, having only one producer of TV. Okay? Maybe the price is low, is the best price possible, but if there's only one guy offering the news, that's called the Pravda, and I don't like it. Okay? So I think that this should be a citizen standard that should be applied, and modern political economy is very easy, very good at elaborating criteria, and actually, through advertising, the Stigler Center will have a conference on the 14th and 15th of May trying to actually discuss how to implement it, how to make administrable a standard that is different from the consumer welfare standard.
Luigi, can I just follow up one sentence and I'll get Joe in? Even if I hadn't heard what you said, I would still not like having a highly concentrated market for reasons that have nothing to do with politics or citizen welfare. Can you help me see a distinctive implication, like a case that comes out differently? Because if I say, oh, we should condemn this 3-2 merger because citizen welfare, because I don't want 2 Pravdas, I'd rather have 3 or something.
Okay.
You see where I'm going,
No,
right? I mean,
absolutely.
economics delivers the same result in this example.
A very simple example. Many of you here are familiar with the reform of the consumer bankruptcy law done in 2004, okay? And my reading of the literature is that everybody, including the Republican senators, were shocked by how much the industry steamrolled everybody in Congress to get their view. Why? Because in the process there has been a huge consolidation of the banking industry. So they speak with only one voice, and imagine you are really a congressperson or senator who wants to do the right thing. Occasionally there are few that want to do this. You need to listen to 2 or 3 different voices. Okay? Lobbying is not that terrible if you have different viewpoints and they lobby against each other, and maybe the truth might prevail at the end. That's what we believe in academia. But if you have only one voice, there is no chance that you're going to get the right result. It's like in academia, we're going that direction, we all do work financed by Google. So all the work in privacy will be all financed by Google. We're going to have one voice in academia. It's not going to prevail. The truth is going to prevail what Google wants. And I think that that's a problem of concentration. That I think is actually SIBO. For example,
So it seems like
I give you a concrete measure. Where do people go when they retire? If every FTC commissioner go and work for the same firm, and the revolving door is so thing, then you're back to Berlusconi that basically owned the member of parliament. You have a vertically integrated version, and it's not good, okay?
So that took an unexpected turn. I was just gonna offer one way of rendering concrete what you were saying about the bankruptcy statute, which I take it one place to go would be a distinctive implication would be if you had firms that were competing not in product markets, but in lobbying. Let's imagine that it was a non-horizontal merger of an investment bank and a commercial bank. you might say, well, look, they're in different lines of business, and so we don't mind, I don't know, Citi and Travelers getting together. But if they had previously checkmated one another in Congress and ceased doing so, that would be an example of the kind of harm that you have in mind.
Perfect. In fact, in my book, I use actually Glass-Steagall. I used to be not to be a supporter of Glass-Steagall, and then I thought actually Glass-Steagall was useful in many dimensions. One of this is exactly this, to create different interests in an industry so that the different interests will compete against each other in lobbying, and they will favor the truth.
Let me get Joe in here, and then I'll turn back to her.
Yeah, so let me, just a couple comments. One is that our models of the economy are sufficiently imprecise that we can't really be very confident. But one of the things I think that our intuition is that if we have many firms, we're likely to get more innovation than if we have one firm. So even, this is what I think you were trying to get at, Scott. In some ways, the fact that there are many arguments for having diversity. We talk about biodiversity. There are many reasons for having diversity. And the one that Luigi raised is probably the most important. But even from a narrower economic point of view, you want economic diversity. The second, the consequences of not having that are very severe in that we don't really internalize the lack of the adverse consequences from the lack of diversity. The second thing I want to say is, you probably discussed this earlier when I was in here, the consumer standard doesn't look at the performance of the economy as a whole. And it's trying to make our whole social, political, economic system work as best as it can. And we're only working on some levers, but trying to create a competitive marketplace is important, and the consumer standard doesn't really reflect all the dimensions of a competitive marketplace. I also think that one can use rigor in going beyond the consumer standard. We talked before about how a monopsonist can drive down producer prices, and some of that could be passed on to the consumer, but that's still not a good market economy. It's a distorted economy. So looking just at the consumers, I think, is wrong. But I was involved in South African competition law takes a broader public interest perspective. And they were concerned with the entry of Walmart would have an adverse effect on small producers in South Africa, and particularly African producers. And their view was that that was something that was of first order importance in their social, economic, political strategy. And so within their competition law, they required for, when Walmart came in, that it had to provide assistance to make sure that the small African agricultural producers were integrated into their producer chain. And the interesting thing, after the case was over, there was a lot of money that went to that. Walmart said it was actually good for them. After it was over, and they fought, but after over, they said, well, actually, it turned out that, like CRA lending in the United States, that after they got over the fixed cost of doing this, it actually made for a better economy. So I think, it is done within the competition law, and I understand the concerns about going beyond the narrow confines, but I think that there are things that we can do within those confines of competition law to advance a broader view of public policy.
Great. I'm going to turn to Corinne and then to Diana. Before I do that, I just want to point out, sort of highlight something that I think Steve Salop said in the previous panel, sort of in passing, which is that in between consumer welfare and a kind of full-on public interest standard, right, that we just heard about as to South Africa, there are a bunch of intermediate positions, right? You can think of consumer welfare in buy-side cases as being, well, we say consumer, but we don't mean it. Sometimes that's rendered explicit by talking about trading partner welfare, that in a buy-side case, we worry about loss of rivalry that transfers resources from the sellers having predictable distortive effects of the kind that Joe was talking about. Corinne.
So again, so many responses to everyone, but a lot of, anyways. Okay, 2 points. One, I want to push back on the idea that, again, assuming we had a concentration problem, that concentration is bad, right? I mean, we had this debate years ago, and Demsetz and others sort of settled it. There's really no empirical basis to presume any systematic relationship between, market structure, competition, or innovation. And the second thing is, with respect to the South Africa case, I'm not sure how, you're defining sort of a better economy as a result of these behavioral conditions, but there is a nice OECD paper that studies, that does a study of deals of countries where they're imposing non-competition factors like employment or equality, and they find that there's actually many more cases of approving anti-competitive deals than there are of the opposite. I take a look at that. I think that OECD study is interesting.
Briefly from Diana.
Yeah, I think until we have a Democrat in the White House and a Democratic House and a Democratic Senate, we're not going to be getting any antitrust reform, really, to speak of, unfortunately. So we're stuck with the standard, right? And whether the standard needs to change or not, I think is been debated here. But what I will say is, the agencies and the courts have a lot of latitude to adjust how they apply the standard. It's applied very asymmetrically right now. I mean, the economists kind of swooped in and took over the static price effect analysis, and that's been a favorite for the agencies and for the courts. But on the efficiency side, what we've seen over time, if you look at swaths of merger cases, is really just an expansive receptiveness to dynamic efficiencies, static efficiencies, and all unproven, right? I mean, this is really a perversity of antitrust law. There is no mechanism for holding merged companies' feet to the fire on proving that they actually produce their efficiencies. And the agencies will tell you, of course, that they consider that. But I'm talking about looking at companies that have engaged in successive merger, and why can't the agencies actually query them in their investigations about, well, did you actually produce these cost savings? Did you actually push out the demand curve so that more consumer benefits could be realized? I don't think that component has been fully fleshed out. So some rebalancing of the standard on both the competitive effects side and on the efficiency side is in order.
Great.
Can I just say on the consumer welfare, because it's a very American debate in the sense that if you go to, if I think about Europe over the past 20 years, I think mostly what we've done is we started enforcing a smart consumer welfare standard, and it had amazingly good results in many industries in Europe. Now, there are maybe 3 industries in the US where that doesn't work, and maybe you need to adapt it or reinterpret it. But I think as a benchmark, it's just wonderful. And many of the good decisions we've taken at the national level, at the EU level, were 100%, let's just take care of the consumers. And I think it led to excellent outcomes, many fewer political economy issues like Luigi was saying. So I think by and large, it's just a great idea.
So I kind of want to stay on this idea of, we have a little bit of a theme here, I guess, of economists moving beyond relatively narrow accounts of economic effects. Broaden out the lens a little further to think about concerns about political power as part of what we do when we do antitrust. I think most folks in the room are familiar, and we've talked a little bit already about the idea that the Sherman Act was premised in part on concerns about concentrated political power. I teach a 1L reading group here on big tech and Standard Oil. And part of what's fun about it is to sort of dig back into the history. And by dig, I mean, we read excerpts from Chernov's terrific biography of Titan, the terrific biography of Rockefeller, and how control of the political process was, of course, part of what was animating the tenor of the times. Luigi, you've thought about this. We talked about it a little bit, I guess, in the context of citizen welfare and the avoidance of Pravda. But I wondered if you wanted to spend a little more time on that.
Yeah, I think that we do expand, at least some of us do expand behind the narrow limits of economics to understand that, first of all, political freedom does not exist without competition. And I think that without economic freedom in general, and this is an idea that is very much in Free to Choose of Milton Friedman, so I'm on very solid ground here. I would go sort of an extra step that economic freedom does not exist with monopolies. So let me make maybe an old-fashioned example. Suppose we're in a world still of a printed press. If I own the monopoly on paper, I might price it at the most competitive price, but if somebody who I don't like want to print a newspaper, I don't sell the paper. And the newspaper is not printed, and economic freedom is severely affected. I think that monopoly is a restriction of freedom. And the flip side of that is that monopolies like also to restrict freedom. Why? Because if I'm earning rent, I am terrified that I have a democratic government that will try to take away those rents. So unfortunately, it goes both ways. Is without competition, you don't have freedom. But if you don't have competition, you have monopolies. Those monopolies want to be very authoritarian. And I don't need to go back to the old literature on the rise of the Nazi regime in Germany or the rise of nationalistic Japan to say that monopolies lead to fascism. And actually, the troops, the American troops, when they went to Japan, they went to Germany, what did they do? They broke up the monopolies because they thought that that was a way to ensure long-term survivability of democracy. And if Europe now is celebrating the benefits of competition, like Thomas is saying, is also thanks to the Americans that did that. And what I'm particularly terrified is that digital platforms have now an enormous amount of power. Generally, political scientists divide 4 major sources of power is money, mobilization, agenda setting, and consider a national champion. And generally, business that have one don't have the other. Banks have a lot of money. They generally don't mobilize people. Actually, if they mobilize against them. You never see people in the street proclaiming for freedom of banking, okay? So, they don't control newspapers. Leave it to the New York Times. And very rarely, maybe during the financial crisis, we consider national champion, but otherwise we don't. Now, look at the digital platforms. They have money. They control news. They have the power to mobilize people. Think about Uber. They send you messages, lobby in your city hall in order to reduce that tax. And they get people to act. So they have a mobilization power that is worse than the NRA. And in addition to that, now they're national champions. When Zuckerberg was in front of Congress, his lawyer were passing and say, please mention the Chinese as a threat. So we need to have our own local monopolies in order to don't go under the Chinese monopolies. That's basically the choice we have as free citizens. And their power to basically influence the elections is enormous. And even if they don't use it, the threat point is enough. There is an article on The Guardian that that if you use Gmail, depending on which presidential candidates they like, you receive the email in your inbox or you receive it in promotion. So they did a test, this is on The Guardian, so independent source. If you are Buttigieg, 60% of the messages of Buttigieg show up in your inbox. If you're Elizabeth Warren or Bernie Sanders, 0% end up in your inbox. And the difference is you raise money, you don't raise money, you get elected, you don't get elected. That's pretty important.
Let me see if anybody else wants to come in on this.
Yeah, I think Luigi is absolutely right, we talk about the importance of a free market of ideas, and that analogy has been very powerful, but in fact, you don't have a free market of ideas if you don't have ways of transmitting those ideas. And the media are the ways that we do it, and our social media is the way that it's done today. And so if you have a set of media that lacks transparency. Good markets require transparency. That lacks competition. You have monopoly power. That actually, has attributes of, I would say, thuggishness, where you could have trolling. It's a market that is not really working in any way like a well-functioning market. And well-functioning markets don't work that well. But this is so far from a well-functioning market that we ought to be really worried. And that's why, this is, this is not, the full range of issues are not going to be solved by antitrust. But the fact that there's such concentration of power has made this an antitrust problem and exacerbates all the issues with which we're concerned. And I think Luigi put it very strongly, that it is a threat to our democracy.
So just
I was just laughing. You put it very strongly. It's like, I've never heard you not put something strongly.
So,
yeah.
I think the two most dangerous things you can hear when you talk to politicians or lobbyists or both are because China is one, you hear a lot in the US. In Europe, we hear both, because Google and because China. And usually it's used by lobbyists who want to argue that really you should let them do what they want, because otherwise they would be under the umbrella of either Google in one case or the Chinese in the other. And I gotta say, the first time I was very used to hearing these arguments in Europe. Sometimes to tell you how crazy it is, these arguments were used in the case of Alstom and Siemens, the two train manufacturing equipment makers, who wanted to merge to monopoly essentially in most EU market. Thankfully, it was rejected by the Commission, despite heavy lobbying by the government. But even there, you heard the because Google argument, even though really it was about trains. So that's how powerful it is. And a lot of because China. So I think that's the first time I heard that argument in the US, that's when I got scared. Because I realized that somehow the lesson that the US successfully taught the rest of the world were being forgotten here. And now, I still don't think it's hopeless. Like, there's much we can learn. Also, the globalization cuts both ways. Just give you one example. Do you think it is by chance that the Europeans were the only ones who were, thinking carefully about data protection, maybe trying to do something about Google and Facebook? Or is it because there was more distance between the lobbying and the actual decisions? And the flip side, of course, do you think it's by chance that the Dieselgate was brought up by a small startup in the US and then the California regulator? Or do you think it's because the EU regulator were completely corrupt by the EU car industry? I think the answer is pretty obvious, right? But what that shows also is that globalization cuts both ways. As long as you're willing to learn from the other side, in that case, thanks to the Americans, we're going to have cleaner streets and less asthma in Europe. And it would not have happened without, the American regulator. And now when the US finally start to think carefully about data protection, at the very least, they can start to look at GDPR as a building block with all its flaws, but maybe they can improve. And so, GDPR 2.0 would be better than I agree the one in Europe is not that great, but at least it's a starting point. So that's why I don't think we should be too pessimistic.
Can
I add one more point?
Yeah, can I flag? I've been asked to leave a little bit of time for questions. So I'm going to let Joe talk for a minute. I might let one more comment, and then I have time for a question or two. Does that sound right to you?
Yeah.
Okay.
So let me just have one point about the interaction between the lobbying and the size. One aspect of the lobbying that's really been very important in the last few years is the taxation of the digital companies. And because the digital companies are very good, better than any other sector in avoiding taxes, they're able to get more revenues that give them ability to invest more, that creates more of a barrier to entry, and that reinforces their monopoly power, and that it's a vicious circle. And that it really illustrates both the political economy aspects, the lobbying point, but also the barrier to entry on a narrow economic perspective.
Great. Diana, maybe.
Really quickly, so I think this whole discussion, which has been fantastic, again highlights that we need a public policy frame to approach the problem of declining competition and what's going on in digital tech. And I would also add what's going on in healthcare and what's going on in ag biotech. We forget about really how impaired those sectors are as a result of consolidation. So antitrust plays a role, social regulation, economic regulation, interoperability standards, intellectual property law, labor law, trade policy. These are all part of the public policy toolkit. And then second, I really do worry, because we have been monitoring legislative proposals in the 116th Congress. There are a lot of proposals to reform antitrust that is going, I think, not in the right direction. You know, we've got carve-outs and exemption proposals for certain sectors. We have targeted bills for agriculture. And what we need is comprehensive, coherent reform that strengthens and clarifies the antitrust laws. I think this is a really big job that is going to take a whole village to get done.
Audience questions. I see somebody coming up to the microphone. Yes.
Thank you. So I have a question. So multiple of you mentioned about having this standard that goes beyond the narrow focus of consumer standard, which is often associated with just looking at economic efficiency. So I have a question about administrability. So if there are trade-offs, for example, between economic efficiency and political labor considerations, how would you make that trade-off, and where would you draw the line? For example, if you think there should not be one dominant news publisher in the country, would you allow there to be two or three? And so in thinking about how to design a relatively administrable system, how would you, think about designing such a system? Would you put it inside the antitrust regime, outside the antitrust regime? Would you take a consequentialist approach by looking at the effects, or more categorical, structural?
Let me turn to the panelists. Anybody want to?
I think that I would like it to have analyzed separately, because the antitrust people are so in love with their criteria that they're never going to sort of change. So let's leave them do their consumer welfare analysis, which is important, and have somebody else looking at the citizen welfare. And for example, a standard concentration measure of where you get your news, and whether this becomes too concentrated. Of course, you have to make thresholds, but that's true also. That could be a very easy way to sort of analyze.
Graham.
So
No, we have a follow. Someone else can ask a question, but go ahead if you have.
Oh yeah. So I mean, to give you another side, I'm not convinced that you need to necessarily change that much the consumer welfare standard. If you're worried about political power, maybe you can reform campaign finance laws without changing antitrust. See, that's one of the reasons that debate doesn't play out the same way in Europe, is because we haven't had the multiplication by 5 of lobbying and campaign finance expenditure over the past 20 years. But the reason we don't have that is not because they don't want to spend, it's because there are regulations against, So it's not, I still believe as an economist, like to have targeted tools each for one problem.
Mm-hmm. Eleanor, do we have time for one more person to ask a question? One more, yes.
Thank you. What a wonderful panel. I'm glad, I guess Chicago is not our grandfather's Chicago, Professor Zingales. I think you should run for office. I really love the dynamism. Actually went to law school there, and there's still some problems, but that's okay. So the question, in terms of the ex post review, I still am a little confused how we do it, because I understand if you have like a 2-to-1 merger and the cement monopolist raises the prices, that's easy to show, okay, so effects. But with the Instagram thing, like you're tying the Facebook quality to the acquisition of Instagram, but it only had 11 people. How do we know? How do we attribute the alleged deterioration of Facebook to the Instagram acquisition? So I'm just wondering how practical will it be to actually do an exposed enforcement on these things?
I don't know what difference it makes with vis-a-vis looking at the prices. When you see that there is a merger and then you see prices going up, you think that that's not gone well, right? And there is an attribution problem, but generally you're very happy to attribute to the merger the cause of the increase in prices. If you see a deterioration in quality, I don't know what difference does it make. And the quality is data protection.
So you're saying if in the pre-period, you had quality looking like this, and in the post-period, you had something like this, you would have a clean but-for to compare it to, which would have been sort of constant. Right, I mean.
It's the same kind of thing we do all the time ex ante. And you make judgments, you have models, and you argue, hey, there's not going to be.
Because even in the ex ante situation, you're still fighting about what the but-for world would have looked like.
Exactly, and now you have a little bit more data, and so you have a little bit stronger basis for making those judgments, but there will be conflicting models and people different. The only question is, what should be the condition, should you reverse it? Should you fine them for lying to you? And I think in many of these cases, the answer should be you should undo it. They said these were going to be the effects, and they didn't happen. And now, okay, that's what you promised, you didn't deliver, and we'll just undo it.
All right, I'm going to let Joe have the last word. Please join me in thanking the panel.
Okay, stay for just 5 more minutes. I think it's going to be about 5 more minutes, and then we do have a reception in the back. Is that right, Harry?
5 minutes until wine. Oh,
Okay.
there everybody goes. Okay.
All right, so here goes. It's just a wrap up. And these were fantastic panels. All of them were wonderful, brought up great new ideas. We want to take a little assessment as to what did you learn today, Harry?
So let's see. I've got 4 points. Okay. So the first thing that I learned is down with the economists. This started with people. Yeah, Steve Houck is applauding because he's a lawyer. So that began with Paul Romer at the very beginning, a Nobel Prize-winning economist. But also Judge Walker, a little, let's see, in seeing the facts, let's listen to the witnesses and not necessarily to the economists. But as we found out also, it's not down with economics.
That's right. I was going to say, how did you react
But
to
it
Steve
may be
Salop? Steve Salop raised the question, do we put too much weight on the economists? And yet he did not mean down with the economists.
No, he didn't. He's much smarter than that. So it's be careful of the sort of the technician, forcing us into narrow points. But the economists at the end were hardly narrow. So
That's right.
that was
Thank
the
you.
first thing.
Yeah.
My second thing?
Yeah, go ahead.
Okay.
Yeah.
The most controversial thing, which I hadn't really expected, was ex post enforcement, so nascent competition. There was a lot of dispute about that, including, there were just 11 people at Instagram, who cares, to, oh my God, this is a really big problem. And Tim Wu said, oh, it's a feature, not a bug.
Yes.
To go afterwards, and I'll remind his co-author, Scott Hemphill, who said, we're probably not going to do much of that. So I don't know, they'll have to get together on this. Yeah. But, and at the end, Joe Stiglitz saying, well, we afterwards things, so we should take some moves then. So I was a little surprised at how consistently that was a controversial point of doctrine, in a way, how we're going to handle that. Because there's a lot of sort of off-the-cuff statements about, oh, no, all this, the killer acquisitions or nascent competitors, we really, that's clearly that was a mistake, we should have done something, but not so much agreement here, all right? Third thing, what's antitrust about? What's it all about? Could be a song. What's antitrust about? Actually, I was surprised this was maybe not surprised, most consistently discussed through, through all the panels, this consumer welfare standard, what it means. And although Tad Lipsky wanted to narrow it back to Bork, no one else seemed to be interested in doing that. It seemed to be pretty, everyone, we can deal with this, until the end, when it became citizen welfare. What is that? And it sort of exploded at the end, which I liked, but made it a little more complicated. So, then it was freedom and all sorts of things that maybe we could get with competition, but something broader. Desire to work with those two words, consumer welfare, and make it what you want, or to blow up the two words. Maybe Tim's branding exercise. And I have to do the best lines.
Oh, okay. And then
Okay,
I'll
that'll
make
be the
just
end.
a short
Then
comment, and
you
then
have to
we'll
come
go.
in with.
Yeah.
Okay, best lines. First I had 2, but now I have 3. So first was Steve Salop to Tad Lipsky. Once a year I have to agree with Tad, and I agree we're on a great platform. We're in a
Yes,
great
I love
program.
it.
And then I'm going to disagree with everything else. Okay. The other was Tad Lipsky's remark that the new German bill could have been written by Eleanor and Paul Romer. I thought that was pretty good. And then the third, Thomas Philippon's observation that either you are a friend of Uber or you don't get tenure. Now all the academics were listening to that. So that's my list.
Right. Oh, so I think that's great, and I'll make a comment on that and a comment on the program. So it was like bookends. It was wonderful that Paul Romer started out, and through his comments, and I think this was his, in an answer to a question, he said, yes, bigness is bad. And then we had a number of panels that were somewhat more antitrust law focused, and then of course, the wonderful middle lunch where we heard Tim Wu, which was expansive again, and then coming back at the end, which opened it all up. Until we had the last panel, I was thinking that there was actually, in a way, too little Neo-Brandeis, because we see now a real continuum, at least in the rhetoric, of Neo-Brandeis, which is really challenging the existing system and bringing up something which is very much in the public conversation, but when we come together as antitrust technicians, we often don't speak about it, which fits in with the political elections, that there is an elite and there are 95% of the people feeling left out and feeling that the cards are stacked, the deck is stacked. And this brings to up a question of distribution. I mean, distribution of the gains, not just allocative efficiency. And it does put on the table whether distribution, or you could say it in a different way, putting the emphasis on taking down barriers to entry and letting those who have been left out into the market. I see in my work on developing countries that actually coincides with what probably is also allocative efficiency, because so many people have been left out of the market for so long that the answer to get allocative efficiency as well as distributive justice is to tear down the barriers and let more people in. So there is, at one end of the continuum, you might say that the rules do favor the incumbents, and at the other end of the continuum, the rules would favor the left out. And then there's this sort of, long middle ground. But thinking about our current system, breaking down barriers, having right at the point where you have good arguments both ways as to what is an efficient and pro-competitive society.
So, yeah, go ahead.
Yeah.
I thought that was an advertisement for all of you to come to our conference in the fall on antitrust in developing countries, where we can talk more about distribution effects, which we really didn't talk about, I think, today at all. We talked about political power at the end, or this panel did,
yes,
but not
right.
so much
So
about that.
I have a final comment, and this relates to impressions from the last panel, because actually I started to practice antitrust law in the early 1960s. And I did, in my early years and later in practice, read a lot of the legislative history of the Selleck-Kefauver Amendment, which was 20 years before. And leading up to the 1950 Selleck-Kefauver Amendment, making merger law have more teeth, at least Congress thought then, there were huge hearings that were called TNEC, Temporary National Economic Committee, on the causes and consequences of economic concentration. There was definitely a feeling in the country there was too much concentration, and there was a fear of fascism or communism and a middle ground that would be competitive society, a fear of too much public power on one side, a fear of too much private power on the other side, with the competition system being the intermediary. And the arguments that everybody made on the last panel, and also with Paul Romer at the beginning, they fit into this spectrum, talking a lot about freedom, not talking about cost-benefit analysis, but talking about which is the better society of, how much government intervention to make the competition system work, to protect us against not only the power of producers, but also the government.
Can I end with a quote?
Time.
Can I end with one quote, a quick quote?
Yeah, go ahead.
So that picks up on that on the last panel. So the quote is, we're about free markets and a free people. And that's what the United States is about. That picks up on what was in the last panel, I think. The quote was from a speech that Condoleezza Rice gave to the Republican National Convention. So maybe this is bipartisan. Free markets and free people. In that, we have free drinks. So